Welcome back. Today we'll be shifting our focus from civil procedure to contract. This episode is for everyone and not only legal practitioners. How often is it that we enter into contracts with another party? Think about your home, car, cell phone. You would have very likely signed a contract in respect of each. As attorneys, we are inundated with contractual disputes, often because a party has not read and understood the terms correctly. The purpose of this episode is to show you exactly which clauses you must be wary of before signing a contract. Payment terms. Let's start with payment terms. Firstly, please note that the clauses mentioned herein will often have different headings depending on the contract. Clauses pertaining to payment terms will not necessarily have the heading Payment Terms. There are usually several clauses pertaining to payment terms, and such clauses can be found in most sale, service level, loan, lease, sale of shares, and service agreements, amongst numerous others. Clauses regarding payment terms will look similar to the following. The client shall pay to the company an amount of 1.2 million rand, including VAT, for the service, in brackets the service fee, which amount shall be payable as follows: 600,000 rand prior to the commencement date, and 120,000 rand per month from 1 October 2021, and thereafter on the first day of each subsequent month, with the last payment being payable on 1 February 2022. The service fee shall be all-inclusive, and any additional costs including, but not limited to, fuel, vehicle, maintenance, and toll fees shall be borne by the company. The client shall make all payments in terms of this agreement without demand, free of exchange, and without deductions or set-off for any reason whatsoever. The company shall be entitled, in its sole discretion, to appropriate any amounts received from the client towards the payment of any cause, debt, or amounts owing by the client to the company in terms of this agreement. Without prejudice to any of the other rights of the company, from due date to date of payment, the client shall pay interest at the annual prime rate of interest as determined by Standard Bank of South Africa Limited from time to time during the period while the payment is outstanding on all amounts due by the client to the company in terms of or arising out of this agreement. In a lease agreement, these terms could look as follows. The monthly rental payable by the tenant to the landlord during the lease period shall be the sum of 4,000 rand, VAT inclusive, payable monthly in advance without any deductions or demand, and free of exchange on the first business day of each and every month for each month of the first year of the lease period. Upon the lapsing of the first year of the lease period, the rental amount shall increase annually by 6.5%, provided the landlord gives the tenant 30 calendar days written notice of the increase, which increase will take effect on the first calendar day of the month after the tenant receives the notice. Prior to the commencement date, the tenant must pay the landlord a deposit of 4,000 rand. The landlord shall be entitled to set off the deposit against any amount owed to him in terms of this agreement, whether it be rental, electricity charges, key replacements, renovations to and or reinstatement of the unit and or property, and or any other liability for which the tenant is responsible in terms of this agreement. The above are examples of some clauses you could expect to find regarding payments in a contract. So, why are payment terms so important? It is obviously crucial to know the price of the goods or services one is paying for. You must also take note of whether the price of the goods or services will increase periodically or upon renewal of the contract. It is also important to know when, where, and how payment is to be made. Non-compliance in this regard may result in a breach of the agreement. These clauses often indicate the interest rate, if any, that outstanding payments will attract. In loan agreements, the interest rate is imperative. You do not want to be paying an exorbitant amount of interest. Tip: always negotiate the rates of interest on your loan. There are also statutory limitations on the rates of interest that can be claimed. You may not be aware that a deposit is required. This will be mentioned under payment terms. Regarding deposits, most contracts will state that the deposit may be set off against any amount due to the person or company with whom you are contracting. Think about the vehicle that you pay for monthly. Often these installment agreements require a balloon payment. You do not want such a payment to come as a surprise. If you are contracting internationally, make sure payment is made in the currency required. Finally, you need to make 100% sure that you save the correct bank details into which payment must be made. Do not make this mistake. Breach, cancellation, and termination clauses. No one intends on breaching a contract which they entered into with another party. Unfortunately, circumstances change and breach occurs very often. Breach clauses are arguably the most important clauses in a contract. The following is an example of a simple breach clause. Save as otherwise provided in this agreement. Should any party commit a breach of any provisions of this agreement and fail to remedy such breach within 7 business days after receiving written notice from any party aggrieved, and thereby requiring the defaulting party to do so, then the aggrieved party shall be entitled, without prejudice to the aggrieved party's other rights in law, to either claim immediate specific performance of all of the defaulting party's obligations, whether or not due for performance without prejudice to the aggrieved party's rights, to claim damages, or to cancel this agreement and claim damages. Breach clauses can also be more comprehensive. Take, for example, this breach clause in a residential lease agreement. Should the rental or any other sum or sums payable by the tenants hereunder not be paid promptly on the due date thereof, or should the tenant in any other respect whatsoever contravene or permit the contravention of any term of this agreement, or fail in the observance of any term of this agreement, the landlord shall, notwithstanding any previous waiver to the contrary on his part of any of his rights under this agreement, be entitled forthwith and without any notice whatsoever to cancel this agreement and to obtain possession of the property and unit, and for that purpose to take whatever action may be necessary for the immediate ejectment of the tenant from the property, without prejudice and in addition to all other rights available to the landlord, to claim rents already due and such further damages as the landlord may sustain by reason of the tenant's breach or default, including but not restricted to all legal costs and charges payable by the landlord on the attorney and own client scale as a result thereof. Should the landlord cancel this agreement and the tenant dispute the landlord's right to do so and remain in occupation of the unit and or property, the tenant shall, pending the determination of the dispute, continue to pay all amounts due by him in terms of this agreement on the due date thereof, and the landlord shall be entitled to recover, sue for and accept those payments without prejudice to and without in any manner whatsoever affecting the landlord's claim to cancellation of this agreement or of any other nature whatsoever. Should the dispute between the landlord and the tenant be determined in favor of the landlord, the payments made to the landlord in terms of clause 14.3 shall be regarded as amounts paid by the tenants on account of the loss sustained by the landlord as a result of the holding over the tenant of the unit. The tenant shall be responsible for and hereby undertakes to pay to the landlord all expenses, costs, and charges which the landlord may incur arising out of the default of the tenant, including any costs of tracing the tenant, collection commission at the ruling rate, and all legal costs as between attorney and own client. This agreement shall terminate in the following circumstances: upon the death of either party, or upon the insolvency of either party, or on the termination date, provided written notice to this effect is sent by the terminating party to the other party no later than 1 month prior to the termination date. Evident from the above is that breach, cancellation, and termination of the contract are all incorporated into one section. Why are these clauses so important? It is important to know what conduct or omission constitutes a breach. You also need to be aware of what happens when a breach occurs. For example, you may be afforded a period of time to remedy the breach. In the event that the party with whom you are contracting breaches the agreement, you need to strictly adhere to the breach clause. If the clause states that the innocent party must afford the defaulting party 7 days to remedy the breach, you must do so. Simply cancelling the agreement without compliance may amount to repudiation of the agreement. Very important as well is that a breach clause will likely indicate the scale of costs which an innocent party will be entitled to should it have to get its attorneys involved. The costs will be on the scale of attorney and client or attorney and own client. Breach clauses often also reiterate the rates of interest payable on outstanding debt. On a side note, where no breach clause is present in a contract, for an innocent party to cancel the contract, the breach must be material in nature. Domicilium clause. The importance of the domicilium clause is understated. Before I explain why, have a read of the following clause example. The parties choose as their domicilium setandi et executandi, or otherwise known as their domicilium, for all purposes relating to this agreement, including the giving of any notice, the payment of any sum, and the serving of any process at the respective addresses and fax-mail numbers set out in the information schedule. Each party shall be entitled from time to time, by giving notice to the other party, to vary its physical domicilium to any other physical address, not being a post office box or poste restante, within the Republic of South Africa, to vary its postal domicilium to any other postal address within the Republic of South Africa, and to vary its faxmail domicilium to any other faxmail number. Any notice given by either party to the other party, which is delivered by hand between the hours of 9 and 5 on any business day to that party's physical domicilium for the time being, shall be deemed to have been received by that party at the time of delivery. Posted by prepaid registered post to either party's postal domicilium for the time being shall be deemed to have been received by the receiving party on the 7th day after the date of posting. Successfully transmitted by faxmail to either party's faxmail domicilium for the time being shall be deemed to have been received by the receiving party on the day immediately succeeding the date of the successful transmission thereof. Nothing in this clause shall operate so as to invalidate the giving or receipt of any written notice which is actually received by a party other than by a method referred to in this clause. In case you did not know, a domicilium secundandi executandi is a Latin legal term meaning the address nominated by a party in a legal contract, where legal notices may be sent. We refer to this address as a party's domicilium. The reason why domicilium clauses are so important is because service of a notice or pleading at a nominated domicilium address constitutes adequate service regardless of whether you are present at the location or not. Make 100% sure that your chosen domicilium is an address at which all notices and pleadings served will come to your attention. If your domicilium is your residential address and you decide to move, make sure you change your domicilium to your new address. Judgments are constantly granted in default in situations where defendants are not even aware that proceedings were instituted. This is usually because the summons was served by affixing at the domicilium address. This is so important. Arbitration or dispute resolution clause. I personally dislike arbitration clauses, which are luckily not too prominent in agreements. Arbitration clauses may also have the heading disputes or dispute resolution, but I want to specifically discuss arbitration. Arbitration clauses usually take one of three forms. The first type of arbitration clause provides that in the event of a dispute between the parties are required to have said dispute arbitrated before approaching a court for relief. The second type requires that the arbitration process must be followed before approaching a court for relief, unless the relief sought is urgent or is of a specified nature. The third, and probably the type I dislike the most, is one which states that in the event of a dispute between the parties are to proceed with arbitration, but that notwithstanding the arbitration requirements, they may also approach a court having competent jurisdiction for relief. The following is an example of the first type of arbitration clause. Any dispute arising out of or in connection with this agreement, including any dispute as to its existence, validity, enforceability, or termination, will be finally resolved in accordance with the rules of the Arbitration Foundation of Southern Africa, or its successors in title, by an arbitrator appointed by AFSA. There is a right of appeal as provided for in Article 22 of those rules. For the purposes of having any award made by the arbitrator being made in order of court, each of the parties hereby submits itself to the non-exclusive jurisdiction of the Division of the High Court of South Africa having competent jurisdiction. This 11 is severable from the rest of this agreement and will remain in full force and effect, notwithstanding any cancellation or termination of this agreement or any part hereof. Arbitration clauses can also be extremely specific. Here is an example of the second type of arbitration clause. Save is specifically provided elsewhere in this agreement. Should any dispute arise between the parties concerning any provision of this agreement, the parties shall use their best endeavors to resolve the dispute by negotiating, and during such negotiations, the seller and purchaser shall be represented by their duly authorized representatives. Any party may call upon the other party by written notice to meet with the former for the purpose of reaching a mutually acceptable settlement of the dispute within 7 business days after the date of such notice. If the parties are unable to reach a mutually acceptable settlement of the dispute within such period, any party may submit the dispute to the arbitration. The procedure of such arbitration is set out hereunder. The arbitration shall be held at Johannesburg, subject to the approval and consent of the arbitrator, in an informal, summary manner without any pleadings or discovery of documents, and without it being necessary to observe the strict rules of evidence. Forthwith, with a view of it being completed within 21 business days from the date on which the dispute is referred to the arbitration, except where the provisions of this clause provide otherwise, in terms and under the provisions of the Arbitration Act of South Africa, number 42 of 1965, or such other arbitration act as may be enforced from time to time. Save as otherwise specifically provided in this agreement, the arbitrator shall be, if the question in dispute is primarily of an accounting nature, an independent practicing chartered accountant of not less than 15 years standing, primarily a legal matter, a practicing senior counsel or practicing attorney of not less than 15 years standing, any other matter, an independent and suitably qualified person, agreed upon by the parties and failing agreement, nominated by the chairperson for the time being of the Johannesburg Bar Council or its successor body, provided that no person shall be thus nominated as arbitrator who is not readily available and will remain available and be able to deal with this matter expeditiously until its conclusion. If agreement cannot be reached on whether the question in dispute falls under 10.4.1, 10.4.2, or 10.4.3, above or upon a particular arbitrator in terms of clause 10.4, above within 7 business days after the arbitration has been demanded, then the chairperson for the time being of the Johannesburg Bar Council shall determine whether the question in dispute falls under 10.4.1, 10.4.2, or 10.4.3, nominate an arbitrator in terms of the relevant clause, within 7 business days after the parties have failed to agree, so that the arbitration can be held and concluded as soon as possible, within 21 business days referred to in 10.3. This clause shall constitute each party's irrevocable consent to the arbitration proceedings, and no party shall be entitled to withdraw therefrom or to claim at any such arbitration proceedings that is not bound by this clause. Each of the parties hereby irrevocably agrees that the decision of the arbitrator in the arbitrating proceedings shall be final and binding on each of them, will be carried into effect, and may be made an order of any court to whose jurisdiction the parties to this dispute are subject, and may include an award as to cost of the arbitration proceedings. This 10 shall be severable from the remaining provisions of this agreement, and shall continue to be of application, notwithstanding the cancellation or purported cancellation of this agreement. Nothing in this clause shall prevent any party from seeking relief on an urgent or interlocutory basis with any High Court of South Africa having the necessary jurisdiction. An example of the third type of arbitration clause will be exactly the same as the above, save for the last paragraph, which will state something on the lines of, nothing in this clause shall prevent any party from approaching any High Court of South Africa having the necessary jurisdiction for any relief of whatsoever nature. I dislike the first type of arbitration clause mainly because arbitration can be extremely expensive. I dislike the second type because an innocent party may only approach a court directly for urgent or specific relief. I hate the third type because it is pretty much redundant. Essentially, you may either proceed with arbitration or go to court. You're probably thinking, okay, but if you dislike the clause so much, why would it be important? Say, for example, you have concluded a contract containing the first type of arbitration clause. A dispute arises between yourself and the other party. You feel like the other party has breached the agreement, so you decide to issue summons to enforce your rights and terms thereof. You know what will happen once you serve the summons. You will receive a special plea. This is due to the fact that you're obligated in terms of the agreement to resolve disputes through arbitration. You can get smacked with legal costs doing this. You also run the risk of the claim prescribing depending on how long you continue with the action in court. The clause applies to the other party as well. If you breach the agreement, for example, and the innocent party serves by a sheriff a high court summons on you, reliance may be placed on the arbitration clause in your pleadings. However, if the arbitration clause is the third type, you will have no relief in this respect if you receive a high court summons. In terms of the clause, the parties are entitled to either proceed with arbitration or approach a court directly. Suspensive conditions, or conditions precedent. Have you ever concluded an agreement featuring a clause containing suspensive conditions or conditions precedent? If so, did you understand the importance of such a clause? I certainly hope so. Should you be unfamiliar with suspensive conditions, it is important that you take note of what I'm about to say. A suspensive condition can be described as a condition which suspends the operation or effect of any or all of the obligations under a contract until such time as the condition is fulfilled. If the condition is not fulfilled, then no contract comes into existence. Once the condition is fulfilled, the contract and the mutual rights of the parties relate back to and are deemed to have been enforced from the date of the signature of the agreement and not the date of the fulfillment of the condition. Before I simplify the above, let's have a look at a clause containing suspensive conditions, or conditions precedent. The offer and any agreement of lease arising therefrom shall be subject to the fulfillment of all the following conditions precedent: that the tenant timeously comply with all its obligations recorded in the tenant design agreement and signage design agreement, and that the landlord accepts the offer and signs the agreement of lease. Let's have a look at a more comprehensive example. Say for clauses 1 to 4 and 10 to 19, all inclusive, this agreement is subject to the fulfillment or waiver of the following suspensive conditions by no later than 5 on 29 April 2021, or such later date as agreed between the parties in writing. X delivers to Y certified copies of the resolution of the Board of Directors of X, approving the terms and resolving that X executes this agreement, authorizing a person to execute this agreement on behalf of X, and authorize signing powers to a person on behalf of X. Updating SIPC documents regarding equity ownership reflecting the transaction, informing the banks of the transaction and ensuring that Y has signing powers on the account. The allocation of the purchase consideration is contemplated in Annexure C to this agreement. The suspensive conditions may only be waived by Y on written notice to X before the date of fulfillment of the relevant suspensive conditions. The condition in 4.1.2 may not be waived. If the suspensive conditions are not timeously fulfilled or waived, the provisions of this agreement will be of no force and effect, and the status quo ante will be restored, and neither party will have any claim against the other arising from the failure to fulfill the suspensive conditions. This clause does not apply to 1 to 4 and 10 to 19 all inclusive, which clauses will remain in full force and effect. In simple terms, why is it crucial that suspensive conditions are complied with? Well, depending on the wording of the clause, non-fulfillment of the suspensive conditions or conditions precedent may result in either the entire agreement or certain obligations and terms thereof becoming unenforceable. In the latter example, the clause states that in the event of non-fulfillment of the conditions, the provisions of the agreement will be of no force and effect, and the status quo ante must be restored. This means that no agreement will be in existence and that the parties must be restored to their respective positions they would have been in had the agreement never been concluded. It is also imperative to note that where a condition is required to be fulfilled before a certain date, but is only fulfilled after said date, the late fulfillment equates to non-compliance and will have the same effect on the enforceability of the agreement as non-fulfillment of the condition would. An important case in this regard is Pangborn v. Basin View, summarized below. Pangborn took the view that because one of the three conditions had not been fulfilled timeously, the agreement was not binding on it. The court first dealt with the dispute whether one of the conditions was fulfilled. Should it be found that the condition was not fulfilled, and that the agreement was thus of no effect, the dispute about the price and an application to rectify the agreement need not be decided. The condition relating to board approval shall be fulfilled within 14 days of the signature date. Clause 4.5 provided that the parties could, in writing, extend the dates of fulfillment prior to those dates by mutual agreements. Clause 4.6 stated that, in the absence of such extension, if the conditions were not fulfilled, then the agreements shall never become of any force or effect, and no party shall have any claim against any other party, save in the event of a breach of Clause 4, and that the party shall be restored to the status quo ante. Pangborn's Board of Directors did not pass the resolution anticipated in Clause 4.2 within the 14-day period stipulated. Although the other conditions were fulfilled, the effect of the failure of this condition was, so Pangborn argued, to render the entire contract of no effect. This is indeed the general consequence of the failure of a condition. The contract has no legal force. The agreement in Clause 4.1.2 tacitly required a resolution of the board approving the particular sale, not a general resolution giving an officer of the company authority for acquisitions for less than a specified amount. And proof of the specific resolution, duly certified by the chairman and secretary of the company, had to be furnished to Basin View. The letter did not say that the board had resolved to approve the agreement. It said that Hutchinson had to approve it. And there was indeed no resolution, as Basin View now accepts, and thus no proof of it as required. There was therefore no representation that the condition had been fulfilled, and accordingly there was no reliance to its detriment by Basin View on the fact that the agreement had become unconditional. The requirements for estoppel to operate such that the agreement was enforceable against Pangborn were not met. The High Court was thus wrong in finding that the addendum revived the agreement for the sale of the property by Basin View to Pangborn, with tacit terms read in as to the dates of signature and dates for the fulfillment of the conditions. The High Court also erred in finding that the parties had waived the fulfillment of the condition, since the alleged waiver was not only precluded by the express terms of the agreement, but also occurred after the date by which the condition should have been fulfilled. In my view, there was no basis on which to find that the agreement was enforceable. Penalty clause. Depending on the nature thereof, an agreement may contain a penalty clause. Such a clause provides that in the event of non-compliance with any or all of the terms of the agreement, the guilty party will be liable to pay the innocent party some form of penalty. The penalty payable is often expressed as a percentage of an amount payable, but may also be fixed. An example of a penalty clause is the following. In the case of the contractor's delay with the work handover within the deadline pursuant hereto, the client shall charge a contractual penalty of R150 for each commenced day of the delay. The following is another example of a penalty clause. The tenant shall submit to the landlord on or before the second business day following the end of each calendar month during the subsistence of this agreement, a written statement duly signed by the tenant and certified by it to be true and correct, showing in reasonably accurate detail the amount of the tenant's turnover as defined in Clause 7 for each day of the preceding calendar month. Should the tenant fail to comply with the provisions of Clause 3 of Annexure A, the tenant shall be liable in addition to any rental or other amounts payable in terms of the lease, and without prejudice to the landlord's other rights in terms of the lease, for payment of the daily penalty referred to in Section 14 of the schedule, which was agreed at R100 per day. The importance of such a clause doesn't need to be reiterated. You do not want to pay unnecessary penalties. It's as simple as that. Although not entirely relevant for this episode, take note that you should be required to pay a penalty due to non-compliance with certain terms. Before you make payment thereof, consult the Conventional Penalties Act. Section 3 of the Act states that if upon the hearing of a claim for a penalty, it appears to the court that such penalty is out of proportion to the prejudice suffered by the creditor, by reason of the act or omission in respect of which the penalty was stipulated, the court may reduce the penalty to such extent as it may consider equitable in the circumstances, provided that in determining the extent of such prejudice, the court shall take into consideration not only the creditor's proprietary interest, but every other rightful interest which may be affected by the act or omission in question. The section essentially states that where a party feels that a penalty imposed on them is excessive, said party may approach the court for a reduction in the quantum of the penalty, which the court may grant after considering a number of factors. Whole agreement clause. A whole agreement clause in an agreement may not necessarily have a heading. It is often included under the general provisions of the agreement, towards the end thereof. Such a clause will look similar to the following. This constitutes the whole agreement between the parties, and no variation or alteration of or addition to the settlement agreement will be of any force and effect unless reduced to writing and signed by all the parties. No indulgence or extension given by either party shall be construed to be a waiver or novation of such parties' rights, and at all times shall be without prejudice to such parties' rights. Why is this clause important? The main reason why this clause is important is due to the fact that no amendments, alterations, or variations to the agreement will be valid and binding unless reduced to writing and signed by the parties. As an example, say you have concluded an agreement wherein you are required to make payment of the other party's services on a monthly basis. This agreement also contains a whole agreement clause. Subsequent to the conclusion thereof, you are informed verbally by the other party that you may defer payments for the next 2 months and only recommence full payment during the 3rd month. You then proceed to defer payments as discussed, but the other party sends you a breach notice. You do not remedy the breach and the other party cancels the agreement and issues summons against you. You're not stressed because you tell the court that you verbally agreed with the other party that payment would be deferred. Bad news for you is that the agreement contains a whole agreement clause, which clearly states that no amendments, alterations, or variations to the agreement will be valid and enforceable unless reduced to writing and signed by the parties. Your argument of a verbal agreement being entered into cannot succeed. So, if the parties to an agreement with such a clause wish to amend the terms, make sure it's done in writing and signed by the parties. This is usually done by way of an addendum to the agreement. Voetstoots clause. The infamous Voetstoots clause. Voetstoots is a Dutch word that means with a shove of the foot, and implies that a purchaser of property takes said property in its present condition, whether or not it has a patent or latent defect. In simplified terms, a Voetstoots clause stipulates that the purchaser buys the property from the seller as it stands and thereby indemnifying the seller against claims for damages in respect of any defects on the property, whether patent or latent. Patent defects are those defects that are visible, whereas latent defects are hidden and not discoverable through reasonable inspection. Voetstoots clauses can be found in most immovable property sale agreements, but can also be found in movable property sale agreements. An example of a Voetstoots clause in respect of an immovable property transaction is the following. The said property is sold Voetstoots, and according to the extent as it lies at present without warranty of any nature whatsoever, save and accept the express warranties as set out in Annexure A hereto. Furthermore, the said property is sold according to its consolidation diagram, to be approved and subject to the conditions and servitudes that will apply in respect of the consolidation of the property. Neither the purchaser nor the seller shall have any claim against the other in respect of any over or under measurement which may be revealed on any re-survey. The seller shall not be responsible for pointing out the beacons of the property, nor for the costs of fixing and or erecting any beacons or inserting any pegs to clearly define the property. The following is a Voetstoots clause found in a vehicle sale agreement. The motor vehicle is sold Voetstoots, the purchaser acknowledging that he has inspected and test-driven the motor vehicle and is satisfied with its condition. The importance of a Voetstoots clause goes without saying, but I'll say it anyway. If you subsequently discover that the property you recently purchased, whether movable or immovable, has a defect of whatsoever nature, you will not be able to claim damages in respect of said defect from the seller. Thankfully, our law does provide some protection for purchasers in this regard. A seller may not rely on a Voetstoots clause in the following circumstances: where the seller was aware of a latent defect and deliberately concealed or failed to disclose it with the intention to defraud the purchaser, or where the Consumer Protection Act applies to the transaction. The CPA will be applicable if the seller is selling the property in the ordinary course of business and the consumer is not a juristic person whose asset value or annual turnover at the time of the transaction equals or exceeds the threshold value determined by the Minister from time to time. Suretyship. What does suretyship mean? It is where one person, the surety, undertakes to the creditor of another natural or juristic person to perform the latter's obligation owed to the former when the latter fails to perform. Typically, the performance by the surety is one of a financial nature, for example, payment of a debt. Consider the following example. X is the sole director of Y, a company selling shoes. Y enters into a commercial lease agreement with Z, whereby Y will rent a shop at the mall owned by Z and pay monthly rental to Z. To protect its interests, Z may require that X conclude a deed of suretyship for all obligations of Y to Z. A suretyship clause in an agreement could look as follows. This lease is subject to the suspensive condition that X becomes bound to the landlord as surety and co-principal debtor on the terms of the deed of suretyship annexed hereto for all obligations of the tenant to the landlord under this lease, as well as those arising in consequence of any termination thereof. Be aware of the suretyship clause. Well, not so much the clause, but more the actual deed of suretyship annexed to the agreement, if any. A suretyship clause in an agreement is not sufficient to bind a third party as surety. A deed of surety must be concluded. A deed of surety must adhere to the strict formal requirements as set out in the General Law Amendment Act, which requirements are as follows. The deed of suretyship must be embodied in a written document. A person can thus not bind themselves as surety in terms of an oral agreement. The deed of suretyship must be signed by or on behalf of the surety. The deed of surety must set out the identity of the creditor, the surety, as well as the principal debtor, and the nature and amount of the principal debt must be capable of ascertainment by reference to the provisions of the deed of suretyship. The written agreement may be supplemented by admissible extrinsic evidence in this regard. There are further requirements that must be met in order to hold a surety liable. These requirements are the following. The cause of action must be one in respect of which the surety undertook liability. In other words, a surety who undertook liability for rental payments cannot be held liable for debt due by the principal debtor to the creditor in respect of a separate loan. The surety's liability can also not exceed that of the principal debtor, and the principal debtor must be indebted. A surety shall thus only be liable once the principal debtor is in default. A deed of suretyship may also have to comply with further requirements depending on the circumstances. For instance, if the underlying agreement is subject to the National Credit Act, then the deed of suretyship shall also be subject thereto. Another legislative example is the Matrimonial Property Act, which requires that the spouse of a surety must give consent in writing to the other spouse, binding themselves as surety. One can expect the contents of a deed of suretyship to be as follows. Parties concerned. In the suretyship, the parties concerned are X, hereinafter referred to as the creditor, Y, hereinafter referred to as the debtor, Z, hereinafter referred to as the surety. The surety confirms through signature to the suretyship that the creditor has advised the surety to get independent legal advice to make sure that the surety understands his commitment and the possible consequences of his decision in giving the suretyship, and the surety fully understands his commitment and the possible consequences of his decision in giving the suretyship. Preamble. It is recorded that the suretyship is furnished by the surety to the creditor for the due and proper performance of all the obligations of the debtor to the creditor arising from an acknowledgement of debt in respect of a lease agreement concluded between the debtor and the creditor, and in terms of which the acknowledgement of debt, the debtor undertook to pay a principal debt of 1.852 million, set out the full amount there, in 6 monthly installments commencing on 1 April 2022. Suretyship. The surety binds and interposes himself as surety and co-principal debtor in solidum for the debtor's indebtedness, generally to the creditor, howsoever arising from the acknowledgement of debt. Limit. The amount that the creditor shall be entitled to recover from the surety under the suretyship is limited to the amount of 1.852 million. Continuing security. The suretyship shall not be terminated by any intermediate settlement of account, nor by the death, legal disability, sequestration, liquidation, or business rescue of the surety or the debtor. The suretyship shall remain in force as a continuing covering suretyship until all the indebtedness, including contingent liabilities of the debtor, to which the suretyship applies and which are in existence at the date of receipt of such written notice, shall have been paid and discharged. Not a substitution. The suretyship is given in addition to and not in substitution for any other suretyship or security which the surety or any other person may have given to the creditor in respect of indebtedness of the debtor to the creditor. Release. The surety shall not be released from any liability of the surety hereunder, or from any of the debtor's obligations unless such release be in writing, signed on behalf of the creditor by a duly authorized signatory. Cancellation and variation. No cancellation or variation of the suretyship shall be of any force or effect whatsoever unless and until it is recorded in writing and signed by or on behalf of the creditor and the surety. Voidable dispositions. The surety agrees and declares that if any payment which has the effect of reducing or discharging any of the surety's liabilities hereunder should be set aside by order of any court under the laws relating to insolvency, or for any reason whatsoever, or if any such payment is refunded to the debtor or to the debtor's trustee or liquidator by agreement, or should any security be set aside by order of any court or released by agreement, then the surety shall be liable to the creditor as surety jointly and severally for and co-principal debtor with the debtor in respect of the amount of the debtor's indebtedness to the creditor arising from or revived by the setting aside and or refund of such payment or the setting aside or release of such security, notwithstanding that the same may take place after the termination of the surety's liability hereunder in other respects. Certificate of balance. A certificate signed by the creditor or on his behalf whose appointment need not be proved as to the amount owing to the creditor by the debtor and or the surety at any time, the fact that such amount is due and payable, the rate of interest payable thereon, and the date from which such interest is reckoned, shall be binding on the surety and shall be prima facie proof of the facts stated therein. Any notice sent by the creditor to the surety at his chosen domicilium secundii et executandi, or any other address of the surety shall be deemed to be received on the 14th day after the date of posting by prepaid registered post, or on the date of delivery in the case of delivery otherwise than through the post. The surety shall be entitled to change the surety's chosen domicilium secundii et executandi to any other address within the Republic of South Africa, not being a post office box or poste restante, on not less than 14 days prior written notice to the creditor. Indulgence. No indulgence, latitude, or extension of time that may be allowed by the creditor to the surety or the debtor shall in any circumstances be deemed to be a waiver of rights under the suretyship, and the creditor shall remain entitled to require strict and punctual compliance by the surety with each and every provision of the suretyship. Although not always possible, try and avoid signing as surety. It can be life-ruining. Creditors, on the other hand, try and always have a deed of suretyship concluded. Early termination. This clause may not have the heading early termination. It could potentially be found anywhere in the contract. For purposes of this episode, I shall be referencing early termination by an employee of the employment contract and the potential consequences of such early termination. These clauses are often found in employment contracts where recruiters were appointed in filling the position or where training costs were incurred by the employer during the employee's employment. These clauses tend to state that in the event of early termination by the employee, said employee will be liable for recruitment fees, alternatively training costs on a pro rata basis. The following is a clause concerning the repayment of recruitment fees in the event of early termination. Should the employee terminate his or her employment contract within a period of 24 months from date of employment, any recruitment fees which the employer incurs in terms of the appointment of the employee will be repayable by the employee to the employer on a pro rata basis. A clause pertaining to the repayment of training costs in the event of early termination could look similar to the following. The attendance at this training by the employee shall be considered to be in-occupation training of the employee. It is recorded and agreed that the total value of the in-occupation probationary training contemplated by this agreement, which includes time, expertise, and actual disbursements expended by the company, shall be in the amount of 3 times the employee's monthly cost to company salary. In exchange for the in-occupation probationary training provided by the company to the employee in terms of this agreement, the employee agrees and undertakes as follows. The employee shall serve the company for a minimum period of at least 1 year as an employee of the company in terms of the employee's contract of employment, which period shall be calculated from the date of signature of this agreement by the company. In the event of the employment of the employee with the company terminating for any cause or reason whatsoever, be it resignation or any other form of termination of employment, prior to the expiry of the time period in terms of clause 14.6 above, then in such event, the employee shall immediately be obliged and required to pay the sum of 3 times the employee's monthly cost to company salary. The sum of 3 times the employee's monthly cost to company salary shall be immediately due, owing, and payable by the employee to the company, with effect from the date of termination of employment of the employee with the company in the circumstances contemplated by clause 14.6.2 above. Why are these clauses important? Well, the importance is pretty obvious. In the event of you terminating your fixed-term employment contract early, you'll be liable to pay your employer a sum of money for costs incurred by it, whether in respect of training, recruitment, or otherwise. Depending on the circumstances, these costs can be relatively hefty, often exceeding R100,000. If you intend on being employed for the entire duration of your contract, you will not have any issues. Unfortunately, not everyone intends on being employed for the entire fixed term. There are numerous factors which can encourage employees to terminate their contract early. These circumstances can include, inter alia, a toxic work environment, better employment opportunities, relocation, personal circumstances, illness, and lack of growth. In such an instance, the employee will need to decide whether he or she will persevere with the employment or terminate the contract early, opening themselves up to a claim for damages by the employer. This is extremely tricky. If you have no option but to cancel the contract early, perhaps try and speak to HR or whoever the responsible person is about them waiving in writing the repayment of the recruitment or training costs. If you have already terminated the contract, you may, depending on the circumstances, rely on certain defenses should your employer proceed legally. Think about the following scenarios. If your employer demands a repayment of an exorbitant, unreasonable sum of money, you could potentially find relief in the Conventional Penalties Act. Your employer also has its obligations in terms of both the contract and legislation. You could try and argue that you had no option but to terminate the contract early due to a dangerous or unhealthy work environment. You could also argue constructive dismissal. Take note, however, that the success of such defenses will be circumstance specific. Early termination clauses are hard to defend. Be very careful. Thanks for tuning in, guys. I hope that this episode was helpful. If you haven't already, please hit that subscribe button and share our channel with your friends. See you next time.